Dear colleagues, good afternoon, esteemed colleagues and guests. Today is the 15th of September 2021, 6 o'clock Moscow time. I would like to open the Dissertation Council on the defense of Mastilovic Larisa for the degree of Legal Sciences, Major 120003, Civil Law, Entrepreneurial Law, Family Law, International Private Law. Thesis on topic: Debt restructuring is a measure for preventing bankruptcy under Russian European law. By the order of St. Petersburg State University on the 13th of May 2021, number 4822/1, I, Petrov Dmitry Anatolovich, the Doctor of Legal Sciences, the Associate Professor of Entrepreneurial Law in Petersburg State University, was appointed the Chairman of the Dissertation Council. The same order appointed the members of the Dissertation Council: Makarova Olga Alexandrovna, the Doctor of Legal Sciences, Associate Professor, the Department of Entrepreneurial Law; Skvortsov Oleg Yuryevich, Doctor of Legal Sciences, Associate Professor, the Department of Entrepreneurial Law; Karayev Konstantin Borisovich, Doctor of Legal Sciences, Professor, St. Petersburg Institute of Justice; Kamenkov Viktor Sergeyevich, Doctor of Legal Sciences, Belarusian University. Well, he is absent from the meeting. Also, Popendopoulos Vladimir, the supervisor, was to be present at the meeting, and he accessed the conference at 5:45, but unfortunately he's having some technical problems. Maybe he will join the conference a little bit later. He's the Doctor of Legal Sciences, Professor, the Head of the Department of Entrepreneurial Law. But I'd like to address your attention to the fact that the presence of supervisor is not mandatory from the point of view of the procedure. And I will read the review of the supervisor, if possible. He will join the conference. In order to improve the quality of the connection, I would ask dear colleagues to turn off your microphones, but please don't forget to turn on the microphones when you are given the floor. The audio and visual broadcast is being carried out, and live broadcast is organized on the Petersburg State University website. Simultaneous translation is being provided. On the screen of a live broadcast of the Dissertation Council meeting, currently you can see the email address to which all the listeners might send their questions or express their ideas related to the content of the thesis or the presentation by the applicant, the current scientific discussion, thus taking part in the scientific discussion itself. The services will be directed to me, the questions will be directed to me by the technical service, and the questions are to be directly related to the presentation of the applicant and the content of the thesis. It is necessary to indicate the name, surname, position, and the job of the author of the question. The questions not related to the presentation, to the thesis itself and the scientific discussion, as well as anonymous questions, will not be voiced. In accordance with the procedure of awarding the degrees of Candidate of Science and the degree of Doctor of Science of St. Petersburg State University, hereinafter the procedure. The meeting of the Dissertation Council is considered valid if at least 2/3 of the approved membership takes place, no more than 4 people. Our Dissertation Council consists of 5 people. 4 people are present, thus there is quorum. I would like the representative of the Dissertation Council to issue a turnout list. I would like to voice the following procedure of the Dissertation Council with a total duration of approximately 2 hours. 1. Brief information of the chairman about the applicant and the documents provided by the applicant and whether they meet the requirements. 2. A brief report of the applicant demonstrating the key provisions of the research, about 15 minutes. 3. Questions to the applicant based on the report, no more than 2 minutes per questions. 4. Answers of the applicant, no more than 5 minutes for all. 5. Reviews of all the members of the Dissertation Council in turn with the assessment of the dissertation with comments and questions to the applicants. About 10 minutes per speaker. 6. The speech by the chairman with the review of the thesis. 7. Answers of the applicant to the questions and the comments of the members of the Dissertation Council, no more than 20 minutes. 8. Open discussion. Speeches of those present at the presentation at the defense of the thesis with questions and comments based on the topic of the research, no more than 2 minutes per speaker. We would all like to tell all those willing to participate to register in the turnout list and introduce themselves prior to giving this speech. 9. Voicing the questions which were received during the live broadcast of the meeting of the Dissertation Council on St. Petersburg State University website. I'd like to pay attention to the fact that the written questions which require more than 2 minutes to be voiced will not be voiced. 10. Answers by the applicant, no more than 2 minutes per question. 11. Speech by the scientific supervisor, no more than 3 minutes. 12. Discussion by the members of the Dissertation Council before the open voting the results of the defense, during which the sound of the broadcast is muted for 5 minutes. 13. Open roll call, vote count by the chairman of the Dissertation Council with a subsequent entry of the results in the minutes of the meeting. 14. The decision on awarding and non-awarding the degree. 15. The final word by the applicant. Dear colleagues, are there any questions to the order? If there are no questions or objections, I will start the meeting. First of all, I'd like you to mute the sound of your phone. Those in remote access mode, please do not turn off the phones in case of emergency contact. First, brief report by the chairperson. The thesis of Mastilovic Larisa for the degree of Legal Sciences, Major 120003, Civil Law, Entrepreneurial Law, Family Law, International Private Law, on the topic Debt Restructuring is a measure for preventing bankruptcy under Russian and European law, was taken for defense by the order of the University Secretary on the 9th of April 2021, number 2960-1. Larisa Mastilovic conducted her research at St. Petersburg State University. Her scientific advisor is Vladimir Vladimirovich, the Doctor of Legal Sciences, Professor, the head of the Department of Entrepreneurial Law, St. Petersburg State University. The number of published works of the applicants with the main ideas of the research, according to the list provided, are 8 in total. In the indices by the Russian Ministry of Education 3, indices in Web of Science and Scopus 1. The applicant provided the whole package of document for the defense of the thesis. All the documents comply to point 12 of the section 3 of the order. All the documents provided by the applicant, according to the information that I have received from the curator, comply to the requirements. It can be found in the attestation file of the applicant. Their copies can also be found by the officer of the Dissertation Council Department, who is now present at the meeting. Prior to giving the floor to the applicant, I have the question to the members of the Decision Council. Dear members of the Decision Council, do you have any general questions to the applicant? Is there need to name all the documents submitted? No, there is no need. Thank you. There are no more questions. Then, dear colleagues, Vladimir Papandopoulou now is able to join us. So all the technical issues are solved. Vladimir Fedorich, can you hear us? Yes, I can hear you well. We're going to see and hear you as well. The technical issue has been solved. Now our general part is over, so we'd like to move to the second stage of the defense. That is the presentation by Larisa Mastilovic. The floor is yours. Thank you, Dmitry Anatolovich. Good afternoon, dear members of the Dissertation Council, and all those watching us online and offline. The chairman has already voiced the name of the dissertation, so I'll move on. The Irrational Legislature has provided the correct bankruptcy and pre-bankruptcy regulation, taking into account the specific economic situation. However, the global financial crisis caused by the pandemic created the need to introduce new pre-bankruptcy procedures. According to the Russian legislation on bankruptcy, bankruptcy possession is allowed only at the stage of the debt's insolvency or the evidence of its occurrence. There are no European institutions for the compulsory extension of the legal will of the consenting majority of creditors to the dissenting minority, cram-down. There is no cross-class cram-down through which the debtor could overcome the disagreement or even consent of the majority of unreasonable or unscrupulous creditors in case of obtaining the consent of the judicial authority. According to the regulation of Directive 1023/2019, the opposite is true. Bankruptcy prevention is carried out at the stage of solvency. There is cram-down and cross-cram-down, which restricts the rights of non-consenting creditors that were provided with the institution of protection of the best interests of lender, which guarantees each lender who doesn't agree with the procedure, in case of failure of the procedure, to receive the minimum amount for which he would be able to count on then already insolvent debtor in the traditional bankruptcy procedure if the preventive restructuring plan had not been adopted against the will. European preventive restructuring imposing obligations of procedural abstinence only on creditors. It prohibits institutioning punitive procedures and guarantees them only the rights that are already guaranteed by bankruptcy legislation in the framework of potential bankruptcy procedures, without imposing any additional obligations on the debtor, despite the fact that the primary purpose of all the measures taken is aimed at the preservation of the debtor. When it comes to judicial rehabilitation procedure, the preservation of the debtor is no primary goal, but only the intended result. In addition to this, the consent of the debtor is required for the approval of the preventive restructuring plan, and it cannot be overcome either by the judicial authority or by the creditors, unlike the opinion of the creditors. On the other hand, at the non-bankrupt stage, when the debtor is still solvent, creditors are guaranteed bankruptcy right, which have not yet arisen, which indicates a bankrupt legal nature and not a general civil one, as it's commonly believed in the doctrine. The judicial authority had no right to interfere either in general civil legal relations prior to their violation or in bankruptcy proceedings in which the interests of only the majority of creditors are taken into account. However, in pre-bankruptcy procedures, he should have the right to check the good faith and reasonableness of each individual creditor, since he must ensure the interests of all creditors and the debtor, from which the collectivity characteristic of bankruptcy legislation only intensifies. This encourages creditors not to withdraw themselves from negotiations, but provide evidence in defense of their legal position. If the goal of the procedure is to take into account the interests of all persons and the achievement of the goal is likely, then the compulsory extension of the will to the dissenting creditors is not as coercive as if the goal and legal means of achieving it did not provide for their interest, which is a relatively common civil element. The problem is that pure civil regulation cannot ensure the quality of creditors and the pre-bankruptcy stage, since the debtor's initial legal relationship with each of them may be in conflict. In addition, general civil regulation cannot restrict the same general civil private legal rights of individuals for the sake of general interest of all individuals. As for the European Institution for Protection of the Best Interests of Creditors, it should be noted the European legislators does not know at the time of the adoption of the plan of preventive restructuring, and therefore cannot guarantee that the solvent debtor will not become insolvent as a result of the procedure. But one of the conditions for the approval of preventive restructuring plan is the probability of success. The assumption based on the assessment of the debtor and most of the creditors of court. It is debatable that if, nevertheless, the procedure turns out to be unsuccessful, the debtor thus becomes insolvent. At the moment, the amounts of the creditor's claim will differ from the amounts that were at the time of the adoption of the plan for preventive restructuring, when the debtor was still solvent. New creditors, third parties, investors will emerge. The amount of claims will increase and the circle of creditors will expand. How is it possible then, at the time of adopting the plan of preventive restructuring, the state of the debtor's solvency, when specific amounts of creditors' claims and specific number of creditors are fixed, to predict and guarantee the amount of satisfaction of creditors' claims in case of unknown prospect or the onset of the debtor's insolvency and the initiation of bankruptcy proceeding, when all this will be different. The legislator or the judicial authority at the pre-bankruptcy stage cannot, with objective parameters, regulate the causal relationship between the occurrence of financial difficulties and the prospects of overcoming them. Only the internal ones. Thus cannot guarantee the result, therefore the risk must be distributed among all the creditors and the debtor. Therefore, bankruptcy prevention is a type of entrepreneurial activity, despite its bankrupt legal nature. The choice of procedure and measures by creditors says more about the financial situation of the debtor than the legal norms could say. If the legislation governing bankruptcy proceeding guarantees a certain amount of rights to creditors, then the procedure that prevents such proceedings should guarantee exactly the same or more. Russian legal regulation, according to Article 31, provides more rights for creditors than any other procedure. Balance violation due to the economic risk for creditors is restored by the fact that, in the event of successful result of preventive restructuring, dissenting creditors will receive full satisfaction of their claims, which they wouldn't have received upon initiating bankruptcy proceedings. If successful, the willing creditors took the right decision by voting for the procedure. The dissenting ones were mistaken in case of failing, vice versa. At the same time, dissenting the creditors do not bear any consequences. The reason for the impossibility under European law to initiate preventive restructuring by creditors at the stage of insolvency of the debtor lies in the curb-down institution. In other words, the consent of the majority of creditors is not the consent of all creditors, and the initiation of preventive restructuring also prohibits dissenting creditors from initiating enforcement proceedings during the procedure. The advantage of the Russian institution of organization is the speed and completeness of the result. All existing debts are instantly paid off in relation to all creditors, which creates absolute equality of all creditors. That is, each of them has the right to become the one who will pay off all the debts, and the debts will be fully repaid to all creditors. Such absolute equality of creditors is not possible in the framework of bankruptcy proceeding, since at the legal level creditors are all divided into classes in order for some of them to fully satisfy the claims instead of others. The disadvantage of European regulation lies in the fact that only part of the claims is guaranteed to be met through the institution of protection in the best interest of creditors, and still after a while. Therefore, the volume of rights protected by the Russian Institution for Prevention of Bankruptcy exceeds the volume protected within the framework of European preventive procedure. However, the chance for initiating and carrying out said procedure is higher within the framework of European regulation, since all the persons jointly carry out the rehabilitation of the debtor. European regulation is a long-term preservation of the debtor in the market. The equality of creditors in the regulation of Directive 1023/2019 is relative and resembles the equality provided in bankruptcy proceeding, in that all creditors are guaranteed protection of the best interests of the creditor, but no more. The protection of the debtor's interests at the expense of creditors is provided for in Article 11 of the Directive, which allows creditors to receive only an amount that does not exceed their initial claims against the debtor. Therefore, the question arises why the secured creditor would voluntarily agree to the procedure, as a result of which cannot get more satisfaction than what is already guaranteed to him by law. The guarantee imbalance between the right of consenting and dissenting creditors are judicially ensured by Article 6 of Directive, in that dissenting creditors, interested parties, have the right to be informed about the progress of the procedure and to participate in preventive restructuring. For example, they may terminate the application of certain measures of the entire procedure if they prove that it's no longer necessary or violates their rights and interests. Thus, the directive did not regulate the minimal low threshold for the required consent of creditors, but it did adjust the upper threshold. This means most of the creditors. But most of creditors can vary from 51% to 75%. The lower the percentage, the closer it is to 51%, the fewer creditors must agree. Thus, the debtor has more rights in relation to the creditors and more concessions are expected from them. The easier it is for the debtor to initiate the procedure. So this may stimulate the debtor not to rush into initiate the establishment of the procedure, since it will not take so much time within the framework of negotiations to obtain the consent of a larger percentage of creditors. The percentage approaching 75% is also controversial, since it's difficult to obtain the claim of a large number of creditors, given that their interests are likely to be heterogeneous. One of these conclusions, the candidate for the Dissertation designed for the Russian legal order, a separate authors institute, extrajudicial preventive rehabilitation agreement, EPRA, where the consent of all 100 creditors is required. Therefore, there will be no risk for the Russian legislative institutions, cramp down or cross-clamp down. It can be terminated within a certain period only for creditors and the debtor agree to this. Each debtor can terminate the preventive restructuring procedure if he proves that it infringes on his right and interest, and the amount of satisfaction the creditor's claims in case of successful preventive restructuring cannot exceed the initial amount of the claim, while at the same time EPPA can. Preventive restructuring, as well as EPPA and judicial rehabilitation procedures for bankruptcy and bankruptcy proceedings, are collective in nature, since their legal effect applies to all creditors. On the contrary, according to already well-known European doctrine expressed by the world-famous German professor Matthaus, an expert on debt restructuring and co-author of Directive 1023/2019, cram-down and cross-class cram-down are characteristics of both bankruptcy and the pre-bankruptcy procedure. Pre-bankruptcy pre-right is when a solvent debtor enters into agreement with certain relevant creditors, not all of them, where the agreement will not be compulsory, extended to person not participated in the agreement. This is the concept of Dr. Matthaus, presented in the book Saving Business in Bankruptcy Law, the report of the Institute of European Law, which is translated into Russian. According to the applicant, the compulsion to spread the will of some to others is not an essential characteristic critic of pre-bankruptcy procedures, but on the contrary, voluntary consent of all creditor is even more indicative of the pre-bankruptcy nature. According to the applicant, this is more important in determining the bankruptcy regulation than the criterion of voluntariness or compulsion in the spread of consequences, which is not a novelty. As part of judicial rehabilitation procedures for bankruptcy, contexts are also concluded, but this doesn't give us the right to qualify this procedure as general law, but as bankrupt, even if all creditors give voluntary consent, which is theoretically possible. This is an analogy with pre-bankruptcy regulation. The novelty of the thesis is the proposal to consolidate a new principle in legislation where the good faith legal will of a solvent debtor and all his creditors manifested in order to prevent bankruptcy should be sufficient for the onset of legal consequences that traditionally arise in case of initiation of court proceedings in a bankruptcy case on the stage of insolvency of the debtor, instead of the current application of the norms of general civil law. The pre-bankruptcy stage does not coincide with the stage of the creation of the initial general civil legal relations, but will follow it. Therefore, it's not worth applying the general civil regulation in the pre-bankruptcy regulation. The applicant proposes to consolidate a new principle, namely, conscientiousness in bankruptcy prevention procedures should have a higher standard than the standards provided in general civil regulation at the stage of the debtor's solvency. Thus, it is required to restrain the creditor's own interest in favor of others. If the bankruptcy proceeding is protracted, the debtor has no interest to prevent bankruptcy within the framework of preventive restructuring. And if it is pro-creditor, then this stimulates the debtor to be dishonest and withdraw assets on time. So to say, So the applicant proposes to abandon the eternal struggle in the doctrine between pro-creditor and pro-creditor positions and for debtor position in favor of pro-social position in the regulation of pre-bankruptcy legal positions. The debtor should not be viewed too narrowly as a person who has a debt. Employees have the same priority goal as a bona fide debtor. That is the preservation of the debtor employer when any of the creditors file an application for initiating bankruptcy proceeding. Unlike creditors who continue their activities, say just with another business partners, employees remain without funds for a long-term existence. When it comes to judicial rehabilitation procedures, measures are chosen by creditors, and workers cannot influence the choice of measures. Therefore, rehabilitation can be provided at the expense of the interests of workers or employees in order to achieve economic benefits for creditors and the debtor. The doctrine doesn't yet cast doubt on the fact that prevention of bankruptcy has an exclusively general civil legal nature. And since insolvency is a legal condition both for preventing bankruptcy and for initiating bankruptcy proceedings, it can be concluded that the presence or absence of solvency is not a criterion for predetermining the bankruptcy or legal, general civil legal nature. It's worth considering how the same financial condition of the debtor, that is the presence of external signs of bankruptcy, should be the foundation for conducting bankruptcy proceeding and for judicial rehabilitation procedure, as well as preventing bankruptcy, taking into account that their goals are opposite. If the legal criteria coincide, then the applicable law depends only on the subsequent discretionary will of the creditors and the debtor. Bankrupt if one of them has filed an application to the court to declare the debtor bankrupt, or just general civil in case of their pace of behavior. If the criteria start to differ, and they could be a stable life demarcation between the grounds for applying general civil or bankruptcy regulation. The interest of creditors doesn't always consist in the immediate satisfaction of the claims. Sometimes it consists in retaining their counteragent, the debtor, so as not to incur expenses on participation in litigation and in search for new counterparties. According to Russian regulation, in accordance with Article 31, creditors are no less interested in the debtor's recovery from debt himself and because of the full and immediate satisfaction of the claims of all creditors. According to European regulation, the creditors who support the use of preventive restructuring expect that the amount received will ultimately be higher than what they would have received in the framework of bankruptcy proceeding. In accordance with Directive the debtor has the right to choose to initiate the preventive restructuring procedure or not to initiate one. If the debtor initiates it, then the debtor, on the basis of corporate regulation, voluntarily refuses it in favor of the bankruptcy. If the debtor decides not to initiate the preventive restructuring procedure, then within the framework of corporate or contract law, can carry out the restructuring. The preventive restructuring plan could not have existed if there had been numerous initial legal relations between the debtor and each of the creditors. The preventive restructuring plan does not change these legal relations, but rather postpones their application. Therefore, it cannot be characterized simply as a general civil regulation, since there is no inherent element, the independence of legal relationship. Contractual legislation gives the debtor the freedom to choose goals, while in the framework of preventive restructuring, there's only one goal, that is prevention of bankruptcy. And the means of achieving it are determined not only by the stakeholders, but by the judicial authority. By initiating bankruptcy prevention, the debtor acknowledges that he or she is in need of support of all creditors and will not overcome financial difficulties in his own without the help of individuals. Therefore, the debtor, using the general civil rights, should also have the right to voluntarily refuse them in favor of bankruptcy regulation, provided that ultimate goal is to prevent bankruptcy. Thank you for your attention. Thank you very much. Now I have the question to the members of the Decision Council. Are there any questions related to the report, pointing out the main provisions of the thesis? No, there are no questions. Then we move on to the next stage. Reviews of the members of the Decision Council with their assessment of the research and the voicing of the external reviews. The applicant might respond to the reviews one by one or after all the reviews being voiced. I'd prefer to answer all the questions at the end. Yes, I've seen the reviews and many have similar questions. Thus will save some time. So we'll start with the external review. The review was received from Professor Stefan Modaus, Wittenberg University, Martin Luther University. So first we'll listen to the review. I will ask the interpreter to voice the review, and the review will be voiced in English, and then it will be interpreted. Dear colleagues, please put on your headphones. Debt restructuring is a measure for preventing bankruptcy under Russian and European law by Larisa Mastilovic. Review of the dissertation for the State University of St. Petersburg. Dear members of the doctoral committee, I am honored to assist in the process of reviewing of the dissertation of Larisa Mastilovic. The selected topic of business rehabilitation options and procedures is a very timely one. Debt restructuring options have observed the attention of legislation across the world already before the pandemic. The need for well-adjusted restructuring procedures will be even more urgent when pandemic support measures are lifted and supported businesses will need to readjust their debt burden. I understand that the Russian legislator is considering law reforms in this area of law, as well as including restructuring mechanisms that prevent a formal bankruptcy. Ms. Mastilovic's dissertation fits well within the policy discussion. The basic idea that a debtor who is actually unable to pay their dues may nonetheless disagree with their creditors to lift the debt burden in order to continue the business and overcome the insolvency situation has been accepted almost globally, and many jurisdictions have introduced relevant debt reconstruction procedures in their bankruptcy laws since the 1990s. This includes Germany and much more recently Russia. The aftermath of the financial crisis of the 2000 created the idea to expand court-based debt restructuring support to debtors who are not insolvent already, but only foresee a scenario in which the insolvency is likely. The legal modification of debt requires the debtor to come to an agreement with the creditor. While this is difficult to achieve with a single creditor, it becomes even more complex when a coordinated attempt to restructure the debt owed to a group of creditors. At the same time, the growing experience with the restructuring plan in bankruptcy proceedings provided a set of tools that are obviously useful in achieving coordinated debt restructuring. In the 2010s, many jurisdictions around the globe have followed this line of thought and introduced one formal proceedings or even a set of procedural options where a restructuring toolbox is made available to a debtor who is not yet solvent. Their common function is to avoid bankruptcy of the debtor in a timely process of debt adjustment. The EU legislator even initiated and in 2019 adopted a binding directive mandating all member states to introduce such preventive restructuring procedures in their laws. Most prominently, Germany and the Netherlands introduced such procedures on the 1st of January 2021. The dissertation written by Larisa Mastilovic discusses the possibility and best ways to adopt a similar toolbox into Russian law. The discussion is perfectly timed and it connects to the current debate in Europe and its insights. It provides stakeholders in Russia with relevant insight and may address common concerns. Mr. Mastilovic convincingly answers the underlying question whether preventing procedures are actually required at all in jurisdiction, where things seem to have worked well without them. It should be remembered that U.S. law only allows a non-consensual debt reconstructing in bankruptcy proceeding, which in extent the debtor may access anytime voluntarily without proving insolvency. Germany initially followed this approach when reforming the insolvency law in the 1990s. The U.S. system works well because the perception of stakeholders and the public of voluntary Chapter 11 debt reconstructing procedures is clearly different from that of Chapter 7 bankruptcy liquidations. Chapter 11 procedures do not carry the negative image of bankruptcy. It has proven difficult to establish a similar public understanding in other jurisdictions. Germany is a good example that outside the US, any bankruptcy process is perceived as a bankruptcy process. So the obvious idea is to separate the early debt restructuring option from the need to enter formal bankruptcy proceedings. Such preventive debt reconstructing procedures are now common in the EU, and they were introduced also in Germany in 2011. Ms. Mastilovic explains convincingly that Russian law would also benefit from their introduction. She is also right in her assessment that the literal perception of European legislation to Russian law would be wrong, page 305, an adaptive solution is needed. Based on this insight, Mr. Mastilovic's dissertation proves a careful analysis of the subsequent question: how shall the new Russian preventing framework look like? Her well-explained answer argues in favor of a differentiated multi-level approach. Indeed, preventive procedures are neither necessarily debtor-oriented nor creditor-oriented, page 360. A closer look at their function, access criteria, procedural requirements, and outcome options reveals that national legislative process possess a significant degree of discretion in devising a functional framework which is capable of addressing the specific needs and institutional settings of their jurisdiction. The expected outcome of any debt restructuring should be good for all stakeholders collectively. Creditors shall receive more under the plan than in the alternative scenario of individual debt reinforcement or of an imminent bankruptcy liquidation, unless they actually agree to receive less in the interest of continued business relationship and future revenue. This general principle already reveals that not all creditors share the same general interest. Public creditors, for instance, are bound to significantly different standards in their claims management than, for instance, suppliers, customers, employees, or bank or debtors. While the immediate payoff may dominate the interests of the first, the latter may well be willing to receive less today in order to receive something for years to come. A well-designed restructuring procedure reflects this diversity in interest, class formation, differentiated treatment, guarantees for dissenting creditors. Overall, creditors shall do better, and consequently one could comprehend such a procedure as creditor-oriented. It is also stakeholder-oriented because other stakeholders, especially employees, are benefiting from a rescue of the business as well. Overall, a rehabilitation procedure will comprise a social principle in the way Ms. Mastilovic describes it, page 311. Looking at the debtors, the outcome is in their interest too. Debtors are able to continue their business with less debt to pay or at least a later date of payment. So rehabilitation procedures seem debtor-oriented. But again, it's worth taking a closer look. The debtor is often not an individual, but a company which comprises a variety of individuals. These are directors, majority or minority stakeholders, some of which are mere financial investors, while others are family business owners whose livelihood depends on the business. The specific outcome of a debt restructuring is not always or necessarily good for all of them. Management may be replaced, shareholders may see their shares transferred or diluted, which again may result in losing a controlling majority even though the debtor is restructured and thus saved from bankruptcy. This conflicted interest quite a close look about safe actions of managers with or even against shareholders and relevant practical means of prevention. I agree with Ms. Mastilovic that disclosure of relevant information about the company debtors' affairs to creditors and the court is key in any restructuring, page 229. A debtor who does not provide full and accurate information shall not succeed in preventive procedures. Creditors who are insufficiently informed shall be well entitled to veto plan proposal. The access to preventive procedures shall indeed, as Ms. Mastilovic explains, not depend on signs of bankruptcy, pages 349-354, but on the ability of the debtor to fully explain the need to restructure. Jurisdiction have typically introduced the involvement of the court in a restructuring endeavour of the debtor in two cases. First, the court is needed when the debtor signs a fully consensual agreement with all creditors, under which rights of potential third parties are affected. In particular, the implementation of right under bankruptcy law, such as avoidance actions, to review the implementation of the contract then prompts the need for a court approval. French and Spanish law features such a conciliation or homologation prominently. Ms. Mastilovic outsought of preventing rehabilitation agreements follow the example of such institutions without copying them into Russian law. The second, and probably more important, type of court involvement aims at sanctioning a restructuring agreement against the veto of some of the creditors' non-consensual agreements. Here, procedures are needed because debtors are not able to conclude a restructuring agreement with all relevant creditors due to holdout creditors. Such restructuring plans of schemes of arrangements are the best restructuring tool available today in many jurisdictions, like for example the United States, United Kingdom, Singapore, Germany, Canada, France, and Spain. Recent law reforms even further relax the requirement for such plans and enable procedure to involve a subset of all creditors only, if, when, such a partial solution is sufficient for the restructuring of the debtor's business and the debtor selected the involved creditors in good faith. Here, efforts to restructure are limited to key financial creditors, while not irritating others, especially employees and public creditors. Ms. Mastilovic decided not to focus her analysis on such plans or schemes based on her assessment that many of such restructuring plans failed to rescue the business permanently. Coercive plans are also not able to impose new obligation on non-consenting creditors, which Ms. Mastilovic sees as a key feature of her proposal of an out-of-court preventive rehabilitation agreement. The chairing focus does not mean, however, that Mastilovic is not aware of the power and efficiency of majority base of preventive plans. Preventive procedures that are able to overcome a veto position of a minority have proven helpful and deserve support as soon as the financial structure of business is characterized by the phenomena of hedge fund distressed debt investment. The origins of the 2019 Restructuring Directive gives proof that national legislators should not discard such intrusive procedures once and for all. In Europe, we have come to the conclusion that the introduction of preventive plan procedures is adequate, provided the creditors may be divided into classes of similar interest and majority in a class suffices to conform a plan based in the fulfillment of fairness tests to minority creditors. Safeguards matter. Ms. Mastilovic indicates on page 349 the Russian court bankruptcy proceeding may well continue to feature such coercive procedures. The aim of her dissertation was obviously not to further details of the process, but to design a new procedural option, which is based on absolute voluntariness. Page 349. I have constrained my review to aspects in the dissertation of Ms. Mastilovic that concern EU law, general bankruptcy law, or contract law principles. I cannot assess to what extent Russian law specifics and legal culture are currently reflected in this dissertation, as I am not an expert in Russian law. In my view, these specifics seem well addressed by the principal approach of the final outcome of Ms. Mastilovic's thesis, because she does neither advocate for a simple implementation of the EU 2019 directive, nor for the inclusion of another procedure under foreign law. Instead, she starts from analyzing the needs of Russian law and seeks options to address these needs specifically. Overall, I can only congratulate the supervisor and the faculty. Ms. Mastilovic presents a very timely and highly relevant dissertation, which she is asking the right questions and provide valuable and balanced answer with specific views to the existing Russian law. I can only recommend you accept the dissertation for the purpose of awarding a PhD degree. Stephen Madhouse. Приватный русский язык. Уважаемые члены диссертационного комитета, я с радостью хочу поучаствовать в процессе рецензирования диссертации Ларисы Мастилович. Выбранная тема реабилитации бизнеса и соответствующих процедур достаточно своевременна. Опции по реструктуризации долга привлекали внимание законодателей по всему миру и до пандемии. Также необходимость отлаженных процедур по реструктуризации будет еще более востребованной, когда меры по поддержке будут отменены после пандемии, и ранее поддержанный бизнес будет требовать корректировки долгового бремени. Я понимаю, что российские законодатели рассматривают реформы законодательства в данном направлении и рассматривают возможность включения механизмов по реструктуризации, которые будут предотвращать формальное банкротство. Госпожа Мастилович, диссертация госпожи Мастилович в данном аспекте встраивается в обсуждение данной политики. Основная идея заключается в том, что должник, который не может выплатить свои обязательства, должен согласиться с кредиторами, снять долговое бремя для того, чтобы продолжать вести дело и преодолеть неплатежеспособность. Это должно быть принято, это принято в общемировой практике, и многие юрисдикции признали соответствующие процедуры по реструктуризации долга в своих законопроектах по банкротству с 1990 года. Так лучше? Сейчас меня слышно? Хорошо, тогда продолжаем. Да. В эти страны входят Германия и в последнее время Россия. Последствия финансовых кризисов 2000-х годов создали или привели к созданию идеи в создании порядка оказать порядка реструктуризации долга в судебном порядке для кредиторов, которые являются уже не являются неплатежеспособными, но только предвидят данный сценарий, в ходе которого может возникнуть их неплатежеспособность. Таким образом, изменение юридического подхода к долгу требует, чтобы должник пришел к соглашению с кредиторами. Этого сложно добиться в случае, когда существует только один кредитор, и становится это более сложно, когда необходимы координированные усилия для реструктуризации долга с участием нескольких или группы кредиторов. В то же самое время растущий опыт по реструктуризации долговых обязательств в процедурах банкротства создает ряд инструментов, которые явно являются полезными в создании координированных усилий по реструктуризации долга. В 2010-х годах многие юрисдикции по всему миру пошли этим путем и ввели формальную процедуру или даже ряд процедур, в ходе которых были предложены варианты реструктуризации долга должнику, который еще не является неплатежеспособным. Их общая функция заключается в том, чтобы избежать банкротства должника благодаря своевременному процессу регулирования долга. Законодатели Европейского Союза даже инициировали и в 2019 году приняли директиву, согласно которой все страны-участницы Европейского Союза должны ввести такие превентивные процедуры по реструктуризации в свою законодательную практику. В частности, Германия и Нидерланды узаконили такую процедуру 1 января 2021 года. Диссертация, написанная Ларисой Мастилович, обсуждает возможность и лучший способ использования соответствующего инструментария или схожего инструментария в российском законодательстве. Такое научное обсуждение является очень своевременным, поскольку оно связано с нынешним обсуждением в Европе и взгляде на данный вопрос. Благодаря нему все заинтересованные стороны в России получают необходимую информацию, и это может помочь в решении общих проблем. Госпожа Мастилович убедительно отвечает на вопрос, основной вопрос, согласно которому являются ли профилактические меры нужными в данной юрисдикции. Потому что кажется, что все достаточно хорошо действовало и без данных мер. Но стоит помнить, что только согласно законодательству США можно без согласия должника реструктурировать долг в случае банкротства. При этом должник может получить доступ к данным процедурам на добровольной основе в любой момент без доказательства собственной неплатежеспособности. Германия изначально пошла по пути данного подхода, когда реформировала закон по неплатежеспособности в 1990-х годах. Система США работает хорошо, поскольку восприятие всех участников процесса и общества главы 11 о реструктуризации долга полностью отличается от главы 7 по ликвидации банкротства. Процедура главы 11 не несет негативного подтекста банкротства как такового. Но оказалось сложно установить то же самое общественное восприятие в других юрисдикциях. Германия в этом плане яркий пример того, что вне США любой процесс банкротства воспринимается исключительно как таковой. Таким образом, очевидная идея отделить раннюю возможность реструктуризации долга от необходимости распространения формальной процедуры банкротства в данном случае превалирует. Такие превентивные процедуры по реструктуризации долга достаточно распространены в Европейском Союзе и были также введены в Германии в 2021 году. Госпожа Мастилович достаточно убедительно объясняет, что российское законодательство также выиграет от введения таких положений. Она также права в оценке того, что буквальная интеграция европейского законодательства в российское законодательство будет, цитата, неверной, страница 305. Необходим здесь адаптивный подход. Основываясь на данной точке зрения, диссертации госпожи Мастилович является собой внимательный анализ последующего вопроса. Каким образом новая программа новая российская превентивная программа будет выглядеть? Ее обоснованный ответ утверждает, что необходима дифференцированная многоуровневая программа с соответствующим подходом. И вправду превентивные меры не обязательно должны быть ориентированы на должника или на кредитора, страница 360. Более пристальный взгляд на их функцию и на критерии получения доступа к процедурным требованиям и результатам показывает, что законодатели на национальном уровне имеют некоторый уровень свободы в разработке соответствующих программ, которые могут фокусироваться на определенных требованиях и институциональных ограничениях собственной юрисдикции. Ожидаемый результат реструктуризации любого долга должен быть приемлем для всех заинтересованных лиц. Кредиторы должны получить больше согласно данному плану, нежели при альтернативном сценарии взыскании долга или неминуемой ликвидации банкротства, за исключением случаев, когда они согласились получить меньше ради того, чтобы в будущем продолжить ведение бизнеса и партнерства и получения прибыли таким образом в будущем. Этот общий принцип уже открывает, что не все кредиторы имеют одинаковый общий интерес. Общественные кредиторы, к примеру, обязаны придерживаться иных стандартов в своих требованиях. К примеру, поставщики, сотрудники или банки кредитора. Их требования могут отличаться. Хотя непосредственная выплаты могут быть основным интересом для первой группы, то есть для общественных кредиторов, для второй группы поставщиков, сотрудников и так далее, она будет готова получить меньше сегодня или в настоящий момент для того, чтобы получить больше в последующие годы. Таким образом, хорошо разработанная процедура реструктуризации отражает это разнообразие интересов, дифференцированный подход и гарантии для несогласных кредиторов. В общем и в целом, кредиторы должны получить выгоду, и, соответственно, можно понимать такую процедуру, как ориентированную на кредиторов. Но также она ориентирована на все заинтересованные стороны, поскольку все остальные стороны, особенно сотрудники, также получают прибыль от того, что бизнес таким образом спасается от банкротства. В общем и в целом, процесс реабилитации могут включать в себя и социальные принципы в том виде, в котором их описывает госпожа Мастилович, страница 311. С точки зрения должников, результат является в их интересе в том числе. Должник также имеет возможность продолжить ведение собственного бизнеса и с необходимостью выплачивать меньше долга или, по крайней мере, выплатить долг в более поздний срок. Таким образом, процесс реабилитации, можно сказать, ориентирован на должника. Но опять-таки нужно взглянуть внимательней. Должник часто является не частным лицом, но является компанией, которая состоит из частных лиц. Сюда включаются и руководство компании, большинство и меньшинство держателей акций, держателей большинства и меньшинства акций. Некоторые это просто финансовые инвесторы, для других это семейный бизнес, владельцами которого они являются, и чье благосостояние зависит от перспектив развития данного бизнеса. И результат реструктуризации долга не всегда или не обязательно будет для них положительный. Руководство может быть сменено, акционеры могут столкнуться с ситуацией, что их акции переданы или разводнены, что также может привести к потере основного пакета акций. Даже несмотря на то, что долг и должник реструктурирован и таким образом спасен от банкротства. Данный конфликт интересов требует более внимательного изучения в плане недобросовестности со стороны управления или акционеров и необходимых мер для предотвращения данных результатов. Я согласен с госпожой Мастилович, что раскрытие требуемой информации по поводу дел компаний или ситуации с должником в отношении кредиторов суду является основополагающей в любой реструктуризации. Страница 229. Должник, который не предоставляет всю и точную информацию целиком и в полной мере, не должен получить доступа к превентивным процедурам. Кредиторы, которые недостаточно хорошо информированы, также могут наложить вето на данное предложение. Доступ к превентивным процедурам должен, как и объясняет госпожа Мастилович, не зависеть на признаках банкротства, страницы 349-354, но на возможности должника полностью обосновать необходимость реструктуризации. Юрисдикции предусматривали участие суда в вопросах по реструктуризации долгов в двух случаях. Во-первых, если судебное разбирательство необходимо, когда должник подписывает консенсуальное соглашение со всеми кредиторами, согласно которому права потенциальных третьих лиц или третьих сторон затрагиваются. В частности, ограничение прав согласно закону о банкротству включает действия по расторжению договора для пересмотра контракта, когда требуется согласие суда. В законодательстве Франции и Испании фигурирует такой термин, как улаживание разногласий или одобрение. Госпожа Мастилович говорит о внесудебной согласительной процедуре, которая идет по пути примера вышеупомянутых институтов, но при этом не стоит полностью копировать их практику и внедрять ее таким образом в российское законодательство. Во-вторых, и, возможно, это важнее, тип судебного вмешательства, нацеленный на санкционирование соглашения по реструктуризации вопреки наложенного вето кем-то из кредиторов, несогласованные соглашения. Здесь необходимы процедуры, потому что должники не могут составить соглашение по реструктуризации со всеми или с соответствующими кредиторами из-за удерживающих кредиторов. Такие планы по реструктуризации или схемы по договоренности являются лучшим вариантом по реструктуризации, который сейчас представляется во многих юрисдикциях, включая США, Великобританию, Сингапур, Германию, Канаду, Францию, Испанию. Недавние законодательные реформы еще более ослабили требования для получения таких планов, и процедуры будут проведены, и для них требуется привлечение всех кредиторов только если. Такое частичное решение достаточно для реструктуризации бизнеса должника, или второе, должник выбрал всех вовлеченных кредиторов добросовестно. Здесь попытки и усилия по реструктуризации ограничены ключевыми или финансовыми кредиторами, которые не включают всех остальных, в особенности сотрудников и общественных кредиторов. Госпожа Мастилович решила не фокусировать собственный анализ на таких планах или схемах, которые, основываясь на собственной оценке того, что такие планы по реструктуризации не могут в долгосрочной перспективе спасти бизнес от банкротства. Принудительные планы также не могут наложить новых обязательств на несогласных кредиторов, что госпожа Мастилович видит как основное требование своего предложения по внесудебному соглашению по превентивной реабилитации, страница 329. Эта точка зрения не означает, что госпожа Мастилович не понимает эффективности и влияния превентивных планов, основанных на большинстве. Превентивные процедуры, которые могут преодолеть право вето меньшинства, оказались очень полезными и заслуживают поддержки, если финансовая структура предприятия характеризуется феноменом проблемных долговых инвестиций хедж-фондов. Истоки директивы по реструктуризации 2019 года доказывают, что законодатели на различном национальном уровне не должны отказываться от таких более сложных процедур раз и навсегда. В Европе пришли к выводу, что введение таких профилактических процедур достаточно адекватно, если кредиторы можно разделить на группы схожих интересов, и большинство в определенной группе соответствует и плану, основанному на справедливости к меньшинству кредиторов. Гарантии таким образом важны. Госпожа Мастилович на странице 349 говорит, что российский суд по процедуре банкротства может также рассматривать такие принудительные процедуры. Целью диссертации было, очевидно, не вдаваться в дальнейшие подробности такого процесса, но разработать новый процедурный подход, который основан на принципе полной добровольности, страница 349. Я ограничил собственный отзыв лишь аспектами диссертации госпожи Мастилович, которые относятся к законодательству Европейского Союза или общим принципам законодательства о банкротстве и договорному праву. Я не могу оценить, каким образом отражены специфики российского законодательства и российская правовая культура в данной диссертации, поскольку я не являюсь экспертом по российскому праву. Мне кажется, что все специфики диссертации здесь хорошо разработаны, и принципиальный подход и результаты исследования достаточно хорошо представлены. И диссертантка госпожа Мастилович не выступает за простое использование директивы Европейского Союза 2019 года в том виде, в котором она была создана, не за внедрение других процедур иностранного права. Скорее, она говорит о необходимости анализа потребностей российского законодательства и поиска опций, которые бы подходили специально для данных целей. В общем и в целом я могу поздравить научного руководителя и факультет, на котором представляет свою работу госпожа Мастилович. Госпожа Мастилович представила достаточно своевременную и актуальную работу, где задаются правильные вопросы и представляются ценные и взвешенные ответы с определенным фокусом на существующее российское право. Я могу рекомендовать данную диссертацию на получение степени кандидата наук. Thank you very much. We have listened to the positive review. The translation of the review is over. Now we move on to the reviews of the members of the Dissertation Council. And I would like to remind you that Larisa will answer all the reviews, so we'll voice the reviews by the members of the Dissertation Council first. So we start with the review by Professor Kamenkov, and I am to voice the review. The review can be found at St. Petersburg State University website, so everyone can familiarize with it. The review says that the dissertation complies with the major, that is major 120003. The topic is relevant. The professor states that the bankruptcy procedure and the finalizing is, and the negative consequences lead to the fact that the creditors and the debtors and the employees to find effective ways of preventing bankruptcy on the earliest stage of bankruptcy. Restructuring of the debt in such a case is an efficient measure of prevention of bankruptcy in many bankruptcy liquidation in many countries. The author believes that currently economic factors might influence the bankruptcy, not only the ill faith of debtors. Thus, the interest of creditors should lie in preserving their counterparts, debtors. The applicant wants to find a new way to preserve debtors and for debtors and creditors to mutually act in order to preserve business. Thus, the relevance of the thesis is obvious. As for the novelty, the thesis is the first of its kind work on regulating restructuring of debt as a preventive measure, and the applicant received specific results which are important for the development of legal science. The scientific basis is conceptually new. At the stage of court rehabilitation proceedings on bankruptcy, as well as the stage of preventing bankruptcy within the context of Chapter 2. Preventive restructuring was introduced, impossibility of its use in court bankruptcy procedures, and characteristic traits in out-of-the-court procedures. The author believes that it is necessary to legally talk about the necessity to prior to having court bankruptcy, having the legal outcome of the bankruptcy. It is also necessary to take into the legal framework the need to prevent bankruptcy at any stage of entrepreneurial activity. The goodwill of the debtor is the possibility of the debtor to prevent bankruptcy. The Russian law also allows to prevent bankruptcy. The main conclusions of the dissertation comply to the methodology and the method of research. The methodological base is formed by hypotheses, ideas, and other information about the economic inconsistency of bankruptcy, prevention of bankruptcy, strategies, concept, and prognosis are in question in the issue of bankruptcy. Many reference materials were used, including those in English. The result of the research is the well-grounded conclusions. The scientific value of the work is that the outcome of it is the development of theoretical and methodological grounds for bankruptcy prevention. Then the results of the research publications are provided. I'm not going to voice that. This information can be seen on the website. It is noted that the layout of dissertation complies with the rules. Fourth, the thesis. It is once again reiterated that the work complies with the qualification and the major. The work has a lot of positive factors. Nevertheless, there are certain drawbacks. The author wants to address additional attention to the general idea of the necessity to prove that it's necessary to specify the criteria of the evaluation of goodwill of the debtor and creditors to initiate and choose the particular tools of bankruptcy prevention. The necessity to provide clear criteria within the framework of general pre-bankruptcy and bankruptcy regulation. That bankruptcy prevention is the priority goal of law in many countries. Nevertheless, the above-mentioned disadvantages do not underestimate the overall positive impression from the thesis. Thus, the work is the work which complies to the regulations and requirements of St. Petersburg State University, complies to the regulations of the scientific major. Thus, in accordance with the procedure, the author, Larisa Novic, deserves to be awarded the degree of candidate of legal sciences. That is pretty much it. Then the author summarizes the main information, saying that the work is relevant, that the mechanisms have been identified, talks about the scientific grounding, foundation, and others. Thus, the work has good conclusions that are put for defense. So, the member of the Dissertation Council, Professor Kamenkov, is in favor awarding the degree of candidate of legal sciences. So, we'd like to thank the member of the Dissertation Council and move on to the next one. Olga Alexandrovna Makarova, could you please voice your review? Dear Chairman, dear members of the Dissertation Council, all those present, in my review, I would like to talk about the relevance of the thesis. It is necessary to find the ways to find the right financial state of debtors and creditors, especially in the wake of the pandemic. In such a case, it's necessary to find the balance between preserving the functioning of the business entities and at the same time not violate the interests of creditors. Thus, different measures, court measures, out-of-court measures, which are aimed at preserving the solvency of the debtor. And certain legal changes are also necessary. If we talk about the restructuring of debts and preventive measures is one of the measures possible. I would also like to pay your attention to the fact that Russian legislator is working on the legislation called the Laws on Restructurization, which talks about cases of insolvency. Larisa Mastilovic talks about preventive restructuring in accordance with the Directive of the European Union. A comparative analysis was conducted according to Russian and European law, and conclusions are well grounded. I would like to pay your attention to the fact that the provisions for defense are novel, in particular as a result of the research new terms and definitions of debt restructuring, preventive bankruptcy were introduced. A number of new institutions is offered for introduction, which is also worth noting. And a number of provisions, novel provisions, can also be seen. I'd like to say that all the provisions stated are well grounded, which is proved by the analysis of the reference books and Russian and European legislation and the legal practice as well. I have a couple of remarks and questions. First of all, despite the fact that such terms as restructuring debt, prevention of bankruptcy, are well disclosed in one part of the thesis, the author should have provide the specific definition in the provisions for defense, at least the definition of prevention of bankruptcy. Second, I agree with the introduction of the new institution out of the course Preventive Rehabilitation Agreement. And the author says that the conditions would be the factual agreement of all the creditors and the debtor, the lack of insolvency of the debtor, and the goal, prevention of its occurrence. Furthermore, this agreement should be a business agreement that would make it different from other types of agreement. The question is, could such an agreement be called an institution? And if it is an institution, then of which branch or sub-branch of the law? If it is an agreement, why can't it be discussed? Should there be a special form of such an agreement? And the third group of questions, which maybe coincides with those by Professor Kamenkov, especially about the principle of goodwill. I suppose this is redundant, that the principle of goodwill are general principles, but sometimes they can differ in the procedures of bankruptcy. With all this more, I object to the proposal of the author that goodwill of the debtor within the framework of general pre-bankruptcy and bankruptcy regulation should be seen differently, and the author offers legal ranging of the term goodwill of debtors and creditors. Is it possible to rate goodwill? And the offered rating in the work did not act as a proof to me. But nevertheless, the above-mentioned disadvantages do not underestimate the thesis as a whole, which has substantial theoretical background and conclusive results. The work presented reached the proposed goals, and the results of the work are important for civil law and entrepreneurial law. The topic corresponds to all the requirements established by the order of the 1st of September on awarding degrees at St. Petersburg State University, and Larisa Mastilovic deserves to be awarded the degree of Candidate of Legal Sciences, Specialization 120003, Civil Law, Entrepreneurial Law, Family Law, and International Private Law. Thank you for your attention. Now we're going to give the floor to Professor Skvortsov. Dear colleagues, first of all, I would like to say that the topic for defense is relevant. The question is, how can we help the debtor save the business? And this is an eternal question. I do agree that this is an eternal question, and there is no answer to that question, and legislators are always looking for answers to that question. That's why I support the desire of the applicant to talk about this topic, and I believe it quite relevant. At the same time, when reading the book, I came to the conclusions which were a little bit uncomfortable. and the negative ideas that I expressed were not easy for me. But nevertheless, truth is more valuable. So I will specify my negative outlooks. I would talk about two groups of reasons. The first group of reasons are of ideological issue, and the second group is related to judicial terms. But I think that it is so, these ideas are so important that I can say that the dissertation does not comply with the 3 criteria that it has to meet. So, first, about the ideological disagreement. The first cause is that despite declaring the opposite, the applicant talks about the protection of the interest of a debtor as compared to the interest of the creditor. Although the applicant states the contrary, nevertheless we can see such a result. And the applicant does not specify why it should be done in this particular way. We have a very positive experience of the development of Russian legislature if we remember the 1990s when the legislation on bankruptcy was formed. We talked about, at that time, about the protection of interest of the debtor. 6 years later, the legislator introduced a pro-creditor legislation, which killed the debtor. 5 years later, again, the new legislation was introduced where the interests of debtor and creditor are well balanced. And in the search of this balance, the Russian legislation is currently focusing on. And this application is necessary. In one cartoon there was quotation, "If I tell to beat you with sticks, you will love me." And the same we are doing here. So we need to beat the creditor so that the creditor then loves the debtor. But this idea is impossible. Certain ideas belong to the macroeconomic sphere, which are linked to other institutions, such as mortgage institutions and so on, and viewing a debtor as the one whose rights should be taken into account at the expense of the rights of the creditor. The second idea is that in Russian legislation, there are no institutions which she offers. This is a wrong idea. This is not the case, actually. The applicant offers to introduce certain institutions, one which she names the agreement on... I'm sorry, I don't want to be mistaken in here. Agreement of out of the court ability. preventive rehabilitation procedure. We do have such an institution. It is known starting from the 19th century. It used to be called an agreement. Currently, it is a peaceful agreement. But this term in relation to doctrine, agreement as the institution of finding agreement between debtors and creditors, can be found and is found. And what the applicant offers is the similar institution. Thus, there is no novelty. But there is a term novelty, which hides the fact that there is already such an institution. But this is a fundamental offer around which the whole dissertation focuses, and all the conclusions are linked to that. Thus, the initial wrong idea leads to the fact that the applicant declares the novelty of the conclusions which are not novel. If we look at all the conclusions, none of them corresponds to the criteria of novelty. So let's have a look at the examples. There is a conclusion that the will of the debtor and all the creditors should be enough for legal consequences, which usually occur when there is a legal proceeding on the bankruptcy case. I was trying to get the meaning of this phrase. What legal consequences do you mean here? Well, I don't want to pick the terms. Maybe not the will. Will is not the correct term. How is this will bound by court? Who is the addressee? If it is an out-of-court procedure, who controls the procedure? So do we need to create an administrative body? Starting from 90s, we know how negatively it all ended. So decisions should be outside the relationship between creditors. And the statement in the first provision is not really clear. Next. You have already mentioned preventive court decision, and to make it unappealable. Dear colleagues, I believe that this is absolutely impossible. This is an agreement, and such an approach destroys the legal system based on the principles of right protection. And what are we to do with the business treaties because of the deforming of the will of the party, or lead to the infringement of the third party rights? Should we prohibit to appeal them? Well, it will lead to terrible law abuse. Well, I'll pause in here. Next. As for goodwill and ill will, the applicant creates the whole theory based on that. I'll criticize the theory briefly. The main idea is that goodwill has to be graded. There should be different types of goodwill. We can use Bulgakov's formula. Fish cannot be second fresh. It is either fresh or not fresh. Either we have goodwill or we don't. And all the attempts to rate goodwill leads to the fact that in one case the same behavior is considered goodwill, and in other cases it's considered bad will. But the author says if the creditor is financially stable but requires immediate compliance with the requirements at the stage of solvency, or without financial ground, it does not agree to preventive restructuring, then it must be considered ill will. What does it mean? I think it's absurd. Somebody owes me money, I tell him to give me money back, and then I have ill will. Legislation might block the will of the creditor and to lead to the right actions and following the requirements. The creditor always has to fulfill the obligations in face of the debtor, in face of the creditor. One more important idea, which leads to my contradictions, which seems novel, is the idea of selling the debtor. I've read these provisions for about 10 times. If we talked about economic sale, of household sale, well, everything is clear. There would be no objections. But the applicant talks about the sale of the debtor as the subject of the law. What does it mean practically? It means that one entity will have the right of property over another. Maybe we misunderstand the thing, what you mean by selling the entity. We need to get into the theory of law. The regulation itself is based on the differentiation of subjects and objects of right, and the subject cannot be the object. It's just impossible. The development of your idea leads to the fact that we can sell people. You can sell grandfather, you can sell children. De facto, people might sell other people, but not according to the law. Even feudal society provided for such sale. Of course, you don't talk about the sale of people, but about the sale of legal entities. but it doesn't take into account the whole spectrum of ideas. And these problems include the ownership right. There is a technique. Let's talk about share sale. That's the selling of the legal entity. But we can't talk about selling of people as entities. Thus, in here, I cannot agree with you. One more remark. You say that it's necessary to sell the subject of law and the possessions. Why should I buy the possessions if I bought the entity, or vice versa? And many questions arise. What happens to the debt if we buy the possessions? Well, for economic viewpoint, for the economic logic, it doesn't comply with any type of logic. You talk about the branch division, and you use the term pre-bankruptcy business, pre-bankruptcy legislation. You use this term very often, and you take it for granted. You don't explain the term. And it is viewed as an axiom, and many of the ideas based on the clearness of the term. But I have significant doubts considering this term. What do you understand when you talk about it? There is no common term of that kind. De facto, as I can see it, pre-bankruptcy legislation is civil legislation. Thus, the introduction of this term was not justified, which also applies to other terms. For example, use such terms as any stage of entrepreneurial activity. Entrepreneurial activity has stages, or the stage of the lack of external features of bankruptcy. So normal activity of legal entity is a stage prior to bankruptcy. Well, I can think that this is linked to the term that you use, pre-bankruptcy legislation. But I don't understand the meaning and the definition of the term. And one more remark that I'd like to pay attention to. In your sixth provision for defense, you say that any prevention of bankruptcy is a type of entrepreneurial activity. I just put a question mark there. That's it. Once again, I want to say, with all positive attitude towards you, I unfortunately have to say that the thesis does not correspond to the requirements. Thank you for your attention. Thank you very much. And we give the floor to Oleg Borisovich. All those present, I'd like to welcome you and to thank you for the invitation to participate in the work of the Decision Council. Prior to voicing my review, I'd like to say the following thing. Oleg Yurovich shared his ideas. I would agree, I would share. When the Kamenkov's review was voiced, then Olga Alexandrovna voiced her review. I thought that it would be easier for me because many conclusions were similar to mine, but when Oleg Yurovich voiced his conclusion, I understand that my task was much more difficult. For the conclusions that I made in my review, they in a way discuss or maybe contradict the ones made by Oleg Yurovich. But I think maybe the defense thus becomes more interesting and is not boring. Maybe it improves the quality of the defense as such. Oleg Yurovich is a friend of mine, but I need to voice the content of my review. And first of all, I'd like to pay attention to the novelty of the topic.
Содержание. Я считаю, что действительно работа актуальна, и актуальность прежде всего проявляется в том, что современное действующее законодательство у нас не содержит нормы, которые регулируют, если мы будем говорить об общих нормах, да, вопросы, связанные с предупреждением банкротства. Я сейчас не касаюсь финансовых организаций, здесь это скорее исключение, нежели общее правило, потому что оно касается только финансовых организаций. И действительно, и Ольга Александровна говорила, что была попытка принятия закона, нормы которого бы регулировали эти отношения, был проект, но так и не нашел своего развития. Есть в нашем законодательстве и 30-я, и 31-я статья закона о банкротстве, однако назвать их нормами, которые бы регулировали эту сферу, не представляется возможным, потому что скорее это нормы рекомендаций, которые нам говорят, что в случае, если между должником и кредиторами есть полное согласие, то они могут воспользоваться общегражданским регулированием. Как представляется, общегражданское регулирование не может образовывать специального института банкротства. И плюс здесь тоже мне хотелось бы обратить внимание на то, что все же, да, безусловно, наше законодательство знает институт мирового соглашения, но здесь, на мой взгляд, трудно говорить о институте мирового соглашения как о предупреждении, именно внесудебном предупреждении банкротства, потому все же эти отношения возникают до возбуждения дела о банкротстве, да, до возбуждения дела, а все же мировое соглашение – это тот правовой механизм, который реализуется после возбуждения дела. Поэтому в этом смысле, безусловно, тема диссертации, она как с теоретической точки зрения, на мой взгляд, так и с практической точки зрения представляется актуальной. Дальше, на что хотелось бы мне обратить внимание, это на то, что те цели и задачи, которые ставит диссертант в диссертации, они достигаются. И плюс хотелось бы обратить внимание именно на такую цель, как адаптация европейских процедур превентивной реструктуризации должника, соответственно, к правовой российской системы. И здесь, на мой взгляд, положительным является то, что диссертант не механически решает эту задачу, просто-напросто перенося институты с европейского действительности на российскую.
Would apologize for the temporary technical failure. The applicant pays attention to the situation in Russia, thus understanding which institutions can be used in our regulation. Thus, the applicant talks about the mechanisms and institutions in European regulation which should not be adapted or used under Russian legislation. In my opinion, the thesis contains that should be talked about separately. And in a way, my review will not coincide with that of the previous speaker. I want to state the positive opinion of the provision number 1, where the applicant talks about goodwill of the debtor in order to prevent bankruptcy should be the basis of providing restructurization. But I understood it as it was directly stated, and I think that Larisa will specify whether what was understood under it. I understand it not as a provision on formulating regulation, but I thought that it was a conceptual approach, that having such a will, having such a desire, should be enough for the legislator to which mechanisms could allow them to restore their solvency. And later on, the applicant talks about the particular mechanisms. The second provision for defense is number 1 and number 5 in the thesis, and is related to the idea of reconsidering pre-bankruptcy legislation.
Регулирование досудебного предупреждения банкротства, да, и
focusing on pre-court bankruptcy prevention. And it would be even better to have a mechanism that could be aimed at prevention of bankruptcy prevention, when the debtor is solvent, until there are outside features of bankruptcy.
Но между тем работа, значит.
Nevertheless, the thesis has certain points for discussion, and I would like to pay attention to the institution of out-of-the-court preventive rehabilitation agreement. And when analyzing the provisions for defense, I also have a number of questions. You say that the basis for the agreement is the agreement of all the creditors. Simple majority, thus, of creditor cannot agree for a certain thing and bind the minority. Then I have a question. Doesn't it happen that the agreement of all the creditors is the instrument of cooperative law or civil law, not of bankruptcy law? Maybe it's more expedient to use the approach when the majority of creditors can bind the minority into following the agreement, since such an approach is more consistent with bankruptcy law. And the second question coincides coincides with all the reviews about the criteria of goodwill and legalizing these criteria.
Хотелось бы конкретные поставить вопросы. Не кажется ли вам, что использование в данном...
Don't you think that using the category of goodwill is not efficient, since in practice such an approach can lead to the lack of clarity and ungrounded court decisions when solving certain cases? In particular, it will be very difficult to state the criteria of financial stability. The debtor might disagree with the financial grounding. Could such an answer be considered the answer without the financial grounds? Nevertheless, all the above-mentioned questions are questions for discussions, and they do not underestimate the positive outlook on the dissertation. And I would like to pay attention to the fact that the thesis of the applicant corresponds to the order by St. Petersburg State University, and the applicant deserves being awarded the scientific degree of the candidate of sciences. Thank you for your attention. Mine is the final review. All the members of the Decision Council have already voiced their reviews. All the speakers, including Professor Stefan Madaus, agreed that the topic is pressing. Definitely the current bankruptcy law. There are only 2 articles dedicated to prevention of bankruptcy, but the articles are not clear. The normative base is not extensive. The main idea of the legislator is that bankruptcy has to be prevented somehow, and all the parties involved have to make certain steps. According to practice, not everything is that easy. If we talk, for example, we talk about those who are controlling the debtor and creating the plan of saving the business. If we take into account the financial side, the problem of subordination arises, and so on. The lack of legislation lead to the fact that people controlling the debtor have the opportunity to save the business, but practically, because of court practice, which estimates their actions rather harshly, are not always ready to take such steps. Often, there is a situation when the majority of businesses and companies against which bankruptcy cases were heard in the court then end up being taken out of the registry of legal entities. Thus, business is cleaned from certain companies. Well, bankruptcy is the mechanism, the ideology of which is to take away inefficient economic agents from the economy. Nevertheless, the expansion on bankruptcy prevention, which is the topic of Mastilovic Larisa, is a good idea. We can agree with. There should be certain regulation. What I liked was that Stefan Madaus talking about the necessity to adopt the normative block prior to bankruptcy, talked about coronavirus infection. Even today, we're all vaccinated, we all wear masks because this is just the case. But the results of coronavirus led to the fact that the macroeconomic situation has significantly changed, and the bankruptcy legislation doesn't take into account this factor. The question arises, should we take this factor into account? Yes, of course we should, because in this case, coronavirus is not the last macroeconomic shock the world is to face. Thus, the provisions deserve to be studied. Some might have critical opinion on that. We have very polar ideas concerning the same points, but nevertheless, some provisions need to be reconsidered and worked on. The majority said that certain provisions require additional work, but any research means that this is not final. It doesn't mean that Larisa wrote a paper. That's it. Nobody says anything in this sphere. Legal science is public science, and the appraisal of the results of the thesis is formed by general consensus. We as a society praise the conclusions. The truthfulness should be proved in practice. The legislation on bankruptcy adopted in 2001 and the law we have now. The law that we had in 2002 is not there. Maybe the names of the chapters are similar, but everything else underwent significant changes. Nevertheless, the provisions of the thesis are well grounded. In my opinion, yes, certain provisions might be critically reviewed, but nevertheless, scientific novelty of some provisions over majority provisions can be seen, which is proved by the analysis of problems. The separate issue is linked to the methodology of the thesis, but we need to take into consideration that Russian language is not native language for Larisa. So I suppose that the language barrier might be seen there. It is not the explanation of the wrong use of terminology, but nevertheless, some people might take that into account. If we talk about the provision, in the second provision, for example, the author says that out-of-court preventive rehabilitation agreement should be considered a type of agreement immune to appeal, incontestable. Why should it be so immune? What situation should be there that enables that? But on page 169, the author says about the impossibility to break the agreement. So there is incontestability, and previously said, then the author talks about the inability to break an agreement. In my opinion, the terminology might not be right, but the idea itself, if at the stage of pre-bankruptcy, we create a preventive rehabilitation agreement outside the court. If it was a court agreement, the court was to formally check the provisions. But the court usually goes further. It does not also always check the compliance with the law requirements, but checks whether the balance of interest is violated or not, how realistic it is to implement the agreement. Getting back to preventive rehabilitation agreement, which is juxtaposed to the bankruptcy legislation. My opinion, the idea is that if we have this non-court rehabilitation agreement, the conditions should be such that when we make this agreement, we would not be able to exit it. So she talks about the idea of providing grounds for complying with this agreement if we have decided to have it. But the terminology, yes, which was not very accurate, led to my remark. The author also talks about the insolvency as the period of preventive measures and the opportunity to use different preventive measures at any stage of the development of business. The second provision for defense, that's the institute, creation or introduction of institute. I don't object against the institution, but I would like the author to provide more arguments considering the first provision for defense. In the third and the fourth provisions for defense, the author talks about the rating of the goodwill of the creditors and debtors, which specify certain measures that to be taken into account when preventing bankruptcy. We could have agreed with the provisions, but how can we create uniformity in assessment of goodwill? But the above mentioned comments do not have a negative effect on the overall positive opinion of the thesis. The thesis, thus, is a well-grounded research work which is relevant to the development of the law. And the dissertation, the thesis on the topic, Debt Restructuring as a measure of preventing bankruptcy and intervention in law, corresponds to the main requirements of the Order 6828/1 on awarding degrees at Superior State University, and the applicant deserves to be awarded the degree of Candidate of Legal Sciences, specialty 120003, Civil Law, Entrepreneurial Law, Family Law, International Law, Private Law. I have finished with my review, so we move on to the next stage. And the applicant can now respond to the comments. It was extremely interesting for me to listen to all the remarks. I will pay most of my attention to Oleg Yurievich Skvortsov, since he asked me most critical questions. That's why I paid with the majority of my attention to. Dr. Oleg Skvortsov concretely noted in his review that prevention of bankruptcy is a eternal question. Although the question is eternal, one shouldn't look for an eternal answer. It cannot be. There is no simple ideal legal solution, but there is ideally adapted legal solution to specific economy. Dr. Skvortsov on page 2 of the review rejects all the proposed dissertation, qualifying them as unfounded and unreliable and without novelty, which is diametrically opposed to the opinion of all the other reviewers. Dr. Oleg Yurievich adds that the applicant uses terminology obvious only to the applicant, such as outward signs of bankruptcy, pre-bankruptcy legislation, and any stage of entrepreneurial activity. Dr. Sergei Kamenkov noted in his review that the applicant has already given an answer, has given definition in terms of the time of any stage of entrepreneurial activity, namely, from the stage of solvency to the stage of insolvency. All 5 reviewers, except for Dr. Skvortsov, had no questions about understanding the terminology of the applicant. But now we can see that material knowledge had certain issues. Dr. Alex Skvortsov criticized the lack of a clear legal differentiation of criteria within the framework of general civil pre-bankrupt regulation, and added that the conceptual range proposed by the author is not only not developed in legal science, but that the applicant does not offer the meaningful interpretation. I'd like to pay attention that in the journal Washington Law Reporter, volume 18, an article was published back in 1890 which talk about pre-insolvency procedures, which is pre-bankruptcy procedure. Today is 2021, more than 131 years have passed. I declare with full responsibility that starting with ordinary students and ending with well-known world-class experts in the authorities of bankruptcy law, everyone knows pre-bankruptcy procedures, and thus this term doesn't need to be defined by the applicant. It's the same if the dissertation candidate was required to give a definition, for example, of legal entity, due to the fact that this construction is often used in the thesis. The applicant didn't make the normative legal distinction between bankruptcy or bankruptcy regulation, which is reflected on page 67. Sufficiency prevented the bankruptcy of financially collapsed economic entities impossible without legal uncertainty. It is achieved by disordered creative solutions, often chaotic. At the theoretical level, the criteria for distinguishing between bankruptcy and pre-bankruptcy are the following. Pre-bankruptcy procedures might be accessible at the stage of insolvency, some at the stage of solvency. In Europe, for example, a debtor can choose certain creditors and create such an agreement with only certain creditors, and this will not be applicable to other creditors. Some types of agreement might be binding. But the main differences exist, and there are general elements. There is not so much misunderstanding as many theories. Nevertheless, the criteria for differentiating bankruptcy and bankruptcy proceeding. Bankruptcy is available only at the stage of insolvency, and the obviousness of it onset of the debtor. The bankruptcy can only stage of solvency. In bankruptcy proceeding, the majority of creditors always have the right to overcome the opinion of the minority of descending creditors and the debtor, here enough to cram down. And in pre-bankruptcy proceeding, without the consent of the debtor, proceeding is not carried out and the opinion interest of each individual creditor is not taken into account. In bankruptcy procedure, the main goal is the sale of property within the framework of bankruptcy proceeding and restructuring of debts in order to best meet the claims of creditors. We are not talking about restructuring the debt as a subject, but about restructuring the debts. And in bankruptcy, restructuring of the debtor is an important goal along with debt restructuring. That's an important aspect. The novelty of the author's compass lies in the fact that when applying measures for restructuring debtors within the framework of bankruptcy regulation, if they apply to all persons, it doesn't matter how legally this was achieved. Cram down, clam down, or de facto consent of all creditors. In my institution, the applicant claims that the good faith of all creditors and debt is sufficient for the onset of legal consequences that arise in the event of initiation of bankruptcy proceeding instead of applying civil law. Dr. Skvortsov criticized at this stage and proposed on different ways the conscientiousness of the debtor, depending on whether we are talking about general civil pre-bumper or bankrupt legal regulation, expresses the question of what legal consequences are in question, whether there are their boundaries, whether they connect the court and creditors. Dr. Alex Skvortsov criticized the candidate's proposal to introduce a gradation of consciousness of the debtor and creditor within the framework of pre-bankruptcy law. As Dr. Alexandrovna Makarovna, who asked a rhetorical question about the possibility of gradation of consciousness in general. Dr. Koraev argues that the criterion of good faith will lead to an unreasonably broad judicial discretion in resolving disputes. And Dr. Dmitry Anatolovich Petrov asks that it's not clear how to ensure uniformity in law enforcement, taking into account the situation nature of the assessment of good faith. I draw attention of reviews that the dissertation candidate does not propose a simple application of the institution good faith from the civil code into pre-bankruptcy legislation. Does not simply duplicate the idea, but writes in the dissertation that the pre-bankruptcy stage creditors afford to think not only about themselves, that is, to agree to initiate preventive restructuring and agree to accept any of those measures that lead to the full satisfaction of creditors' claim. But they also have to agree to additional measures that the debtor needs to preserve the business, in addition to fulfilling their obligations. The problem is that not all reviewers saw from this phrase that in pre-bankruptcy legislation the requirements of good faith to creditors are much higher than those imposed on them under the civil code. Dr. Skvortsov considered it unreasonable and unimplementable in some legal relationship to consider the behavior of a person as good faith and others as dishonest, since there is no clarity in the understanding of what is pre-bankruptcy legislation and some of its relationship with general civil and bankruptcy law, adding that good faith is of the nature of high abstraction. The statement about the abstraction of the term of consciousness is the best proof it is necessary first to transform the scientific term of consciousness from an abstract into a concrete one, and only then legislatively consolidate European institution as crammed down into a bankruptcy term. I offer it for scientific discussion, but not introduction into legislation. That's why I created a special institute which does not create any risks for the Russian legislation. Thus, the applicant praises the Russian legislation that this institution was not adopted prematurely. While the criteria for bankruptcy good faith are being formed, the institution can be introduced in legislation without fear of negative consequences. Dr. Skvortsov argues that there is no novelty in the author's agreement, that such institution is also present. That's the amicable agreement institution. And it hints that the candidate didn't know about the existence of amicable agreement, the analog of which appeared in 1800 in the Charter of Bankruptcies, Article 68 of the Karamzin list. Dr. Skvortsov adds that settlement agreement can be concluded both in judicial and extrajudicial order, and that the candidate and the applicant just normally change the name into the name of the institution. But the applicant draws attention to Dr. Yulovich. The Professor Madaus in the book Saving Business and Banking Law explains that preventive restructuring can be both in court and out of court. This means that the conclusion of Dr. Yulovich-Skvortsov that there is preventive restructuring in the Russian legal order only on grounds that an amicable agreement can be carried out of court is erroneous. Essential criteria in the stage of implementation and restructuring its legal consequence. And I'd like to draw your attention to the fact that the differences between the settlement agreement can be seen superficial level. In the title of Article 150.1, I'm citing the Russian legislation. Russian bankruptcy law states that a peace agreement can be concluded at any stage of the arbitration court's bankruptcy case, unlike my institution, which is acceptable only out of court. 2. Settlement agreement can be concluded only at the stage of the debtor's insolvency or the experience of its occurrence. The conclusion: creditors have the right to initiate a settlement agreement only at the same stage at which they have the right to initiate bankruptcy procedures, while the author's institution proposes the opposite condition: the absence of insolvency or the evidence of its imminent onset. 3. In Clause 2, Article 150.1, it stated that the conclusion of a settlement agreement is accepted by the majority of creditors and applies compulsorily to the dissenting minority of creditors, which is similar to European institution. And everything is present in Russia. And this is why a professor said that I'm asking whether we need such institution. It is applicable to the minority creditors, and the author's institution will be concluded subject to the actual consent of all creditors and debtors. The fourth difference, the title of the Article 157, participation in the settlement agreement of third parties is allowed, which is allowed in Directive /2019, while third parties are not entitled to participate in the conclusion of the agreement. Only the debtor has the right to participate and the creditors who exist on the date of the conclusion. Clause 3 of Article 156 states that the conditions of creditors who voted against the conclusion of an amicable agreement or didn't take part in the vote cannot be worse than for bankruptcy creditors authorized bodies that voted for its conclusion. The author's institution provides for different conditions, better or worse. The agreement of all the creditors is necessary. This is the similar institution to the European Institution for the Protection of the Best Interest. Thus, the author's institution is an original one, not only in relation to the relative settlement agreement, but in relation to European bankruptcy institutions. 6. In accordance with Article 164, creditors have the right to file an application for termination of the settlement agreement. It must be indisputable and indissoluble transaction which will distinguish the institution from other general civil transactions. In accordance with Article 158.1, amicable agreement can be approved by an arbitration court only after the debt and the claims of the first and second priority creditors has been repaid. The institution doesn't establish such prescriptions. paid. And the last one. The Amicable Agreement, Chapter 2, Bankruptcy Law of the Russian Federation, prevents bankruptcy itself, but does not restore the economic and financial prospects of the debtor of the future. It warns that precedes bankruptcy, the onset of signed bankruptcy, which stimulates the debtor to initiate the procedure, without which consent under the current legislation, the bankruptcy prevention procedure cannot be started. Dr. Skvortsov makes an unjustified remark to the applicant that the work is obviously written from a clearly pro-continualist position and is oriented in favor of the interests of the debtor to the detriment of the rights of the creditor, and therefore asks, why should the Russian legislator form clearly long-term legislation to the detriment of the economic interests of creditors, those economically strong entities in which the stability of economic turnover sets? This is the wrong conclusion about the provisions of the legislation. According to European regulation, crammed down, which Skvortsov considers to be contingent, is needed in order to prevent the professional and unfair behavior of creditors, and not to infringe the rights of one group of subjects for the sake of another, which proves the right of veto given to each individual creditor. It is important that any creditor within the directive can disagree with the plan. Moreover, for the turnover, it's important that the business entities do not leave the market. All of them are irreplaceable. The applicant believed that the European legislature should take over the European legislation without adapting them. All the provisions, including cram down, wouldn't write a thesis but sent a letter of recommendation to the State Duma to carry out a professional translation of the directive. In addition, the actual requirement to reach agreement of 100% of the creditors for the conclusion of the Authors Institute of protects the interests of the creditors much better than the requirement to reach agreement of a lower percentage of 100, that is, only the majority of creditors, as is required in action settlement agreement. Thus, the Authors Institution protects the interests of creditors much more than the settlement agreement. The Authors Institution is the institution where debtor and creditor come together to extend that virtually everyone jointly manages the debtor's business. In addition, Professor Medeiros in his interview correctly noted that the dissertation candidate asks the right questions and gives balanced answers, adding that the dissertation candidate doesn't advocate a simple adaptation of the directive, not for adopted procedure for the legislation. That is opposite conclusion given by Skvortsov. The applicant asks a rhetorical question. Is he mistaken when he is accepting the candidate's positions clearly continuing legislation to the detriment of the economic interests of creditors? If at the stage of the debtor's solvency, the creditor's bankruptcy right did not arise. Preventive restructuring in accordance with the Directive 1023/2019 is not a mechanism to bring viable creditors to bankruptcy in order to save one debtor, no matter what, but you just need not to miss such an opportunity when it exists, which provides legal mechanisms through which the debtor can react in time at the first signs of financial crisis. End of quote. Given the advantage to keeping the debtor in the market only at the superficial level of analysis means a continued position, since the statistics presented below in the text will clearly show that the claims of creditors as a result of quotation procedures in practice are unsatisfied. Although it sounds unusual in the scientific community, in the opinion of the dissertation scholar, the pro-continuation position is reflected more in the liquidation of the debtor than in the preventive rehabilitation. Since the bankruptcy proceeded, the debtor is in fact released from debts due to the lack of property. What then is the beauty of bankruptcy proceeding for creditors? That's a rhetorical question. In my opinion, there are no advantages for creditors. Pro-creditor position defended by Skvortsov in the certainty of creditors, if it leads in advance to the satisfaction of their own claims. Is it that lenders will predictably get almost nothing? Dr. Skvortsov argues that the applicant initially formulated a false message. Russian bankruptcy legislation does not provide for the institution of extrajudicial restructuring of debts of legal entities known to European law in order to prevent bankruptcy. Dr. Karayev asks a similar question. Is it possible that the actual consent of all creditors in the institution is the instrument of corporate general civil regulation and not bankruptcy, and proposes to use the principle of forced extension of the will of the consenting majority to the dissenting minority? Taking into account that the current legislation does not prohibit the conclusion of agreements between the debtor and all his creditors on debt restructuring and specifies from the dissertation what features of the institution differ from the general civil agreement, and why does the applicant point out the bankruptcy nature? Almost everyone had this question. Dr. Visly Kamenkova wisely noted the key phrase in the candidate statement, which proves that the candidate was not mistaken, that the Russian legislation lacks the ability to restore the debtor's business while receiving collective guarantees that are provided by the traditional bankruptcy legislation, which cannot be found in the civil law. The applicant believes that in persons who haven't received legal education are that's allowed to conclude any contracts. Well, as I understood that, I didn't know that any entity might make an agreement with any entity. That's why I'm even people who haven't received legal education know it is allowed to conclude any contracts out of court, including those aimed at preventing bankruptcy, debt restructuring. But to draw the attention of reviewers who are skeptical about the institution, this institution is a bankrupt institution. As such, differs from the measures that are carried out by corporate and contractual mechanism. The conclusion of civil contracts is not due to a certain number of certain types of obligatory subjects, while the institution is limited only by the existing creditors at the time of its conclusion, as well as the obligation to conclude it all by all creditors. The consent of all the creditors should not conflict with the norms of the bankruptcy law, especially in terms of legal force. The candidate believes that with a large number of creditors, cram-down is needed so that the negotiations do not drag out. Cram-down is necessary if there are many creditors for negotiations not to drag on. In practice, such an approach will be in demand when the number of creditors is small and their interests are homogeneous and financial conditions stable. So the institution is safer pre-bankruptcy institution. Intuitively, Dr. Karayev understands potential abuse of cram-down. Therefore, in the response says that it is for these it is difficult to say the criteria for the financial stability of the creditors, because the answer of the creditors might be financially grounded, by the others might not agree. For these reasons, the applicant proposes to consolidate the requirement to reach the agreement of all creditors when concluding the agreement. Skvortsov nevertheless claims further that the institution is unnecessary, since it already agrees in paragraph 3 of Article 30 is a more general rule, where before the filing of an application for declaring the debt bankrupt with the arbitration court, debt restructuring is carried out. He argues that this norm is sufficient, that there is no need to introduce new institutions. The problem with the content of Clause 3 of Article 30 is precisely the fact that it's essentially no different from the contractual legal mechanism for debt restructuring, in contrast to the institute of those institutions. The applicant writes, if the debtor was in good faith and was able to restore the solvency his own or without the participation of other person, then he would have prevented bankruptcy voluntarily and without the prescription of paragraph 3 of Article 30. The applicant asks a question: what's the meaning of voluntary reorganization in accordance with Article 31 and the absence of a compulsory extension of the consequences to non-participating creditors, when according to general civil regulation within the framework of contractual legal mechanisms was possible to the debtor to find such a person who paid off the debts for him? That's my rhetoric question. Dear members of the Decision Council, considering that for all creditors and other persons, the rule of Clause 1 of Article 3 doesn't provide for the dissemination of legal consequences of bankruptcy prevention measures, which are compulsory chosen by the debtor independently, then this rule acquires a corporate obligatory nature, despite the fact that it's placed in the bankruptcy law. The position is defended and confirmed by the research in the Ministry of Economic Development, which cites low statistics of the application of paragraph 3 of Article 30, which was wisely noted by another reviewer, Professor Petrov. Who says that in the Russian Federation, bankruptcy preventive mechanisms are rarely used. The position is also endorsed by Dr. Karayev, who correctly notes that Article 3031 are recommendations that indicate to creditors and the debtor the possibility of restoring solvency, but do not provide them with any new legal opportunity for this in comparison with general civil law rules. The applicant is not surprised by the inapplicability of paragraph 3 of Article 30 in practice, since the whole problem of inapplicability is in the general wording of Clause 3 of Article 30. Creditors must often don't even know each other, which discourages both of them and the debtor at the start of the negotiating process due to the unexpected agreement or compromise. Thus, it's necessary to introduce the above-mentioned institution. The statistics of the Judicial Department of the Supreme Court of Bankruptcy in the first half of 2020 provide the following data. The arbitration court considered 12,339 bankruptcy cases. Only 502 cases, the basis for termination proceeding was a settlement agreement. The Ministry of Economic Development published on the 2nd of March 2020 that there are almost 98 enterprises in Russia subject to bankruptcy procedures do not get a change of salvation, while in developed countries the percentage of rehabilitation procedures is quite high, up to 30%. I can add that this doesn't mean that in Europe the bankruptcy procedure is good. This is why that many businesses are saved. The share of satisfied creditors claim does not exceed 5%, while there is a high proportion of cases where no payments are made to creditors at all, that is 60%. Data from federal resources for 2020 stated that rehabilitation procedures were encountered in less than 2% of bankruptcy cases, and debtors' assets were squandered even before the introduction of bankruptcy procedures. In the first quarter of 2021, 39% of debtor companies had no property already at the entrance to the bankruptcy procedure. As a result, 59% did not pay anything to creditors. This is the pro-creditorial legislation. Joke. Dr. Makarova asked a question. How does the provision for the Civil Code on contracts combine with the author's institution? Dr. Skvortsov argues that the proposal of the applicant to endow the institution with an undeniable regime is absolutely unacceptable. This will lead to colossal evil. The fears of the reviewers are groundless, since the applicant unequivocally prohibits both the participation of third parties and the infringement of their rights within the framework of the author's institution, and the disputability is justified by the fact that all creditors and judicial authority give consent. The risk of entering into the PDA and the risk of deception, threat of deception, is minimized by requiring the consent of all creditors and the obligation of all the court to actively participate in its conclusion. All the ground is being checked, and no other institution guarantees that. Next, the risk of creation of the institution under coercion is minimal. If the debtor has ill will, he will agree with other creditors, ill will creditors. If all the creditors take part in the proceedings, what is a point for the debtor to bribe all the creditors. This institution is positive from this point of view. It has fewer risks. It is appealing for creditors, since it's much more difficult to get the consent of all the creditors than just of some. There's no economic idea of corrupting all the debtors. There is very little chance that the creditor, the debtor, finds a way to deceive some of the creditors. Take into account the requirements of the consent. If a deception takes place, all parties involved take on the burden of compensation for harm to such a person. Dr. Skvortsov categorically disagree with the candidate's proposal to legally establish an overestimated standard of consciousness of pre-bankruptcy procedures. The applicant points out that if the creditor is financially stable, nevertheless requires immediate satisfaction of the claims at the stage of solvency of bona fide debtor, or doesn't agree to carry preventive restructuring without financial justification. Dr. Skvortsov believes that such a creditor should be considered conscientious, arguing by the fact that any creditor has the right to strive to ensure the rights, including the relations to insolvent debtors. Once the legislation that if viable creditors, this will lead to the bankruptcy and the entire turnover will collapse. Dr. Kamenkov does not share the views of Dr. Skvortsov and agrees with the applicant that liquidation of the debtor is not beneficial either for the economy, for social rights, nor for creditors. The dissertation states that if one creditor approves that the procedure will cause financial difficulties, neither the court nor the majority of creditors, despite the eventual high level of economic prospects of the debtor, will not be able to initiate preventive restructuring. And also, if creditors withdraw themselves from negotiations, should create a presumption of their dishonesty and the lack of their support to the debtor. In case of active participation in negotiations, should create a presumption of unfairness and hopelessness, not of them, but that of the debtor. In the text of bankruptcy prevention, only those creditors who strive to find a reasonable balance between their interests and the interests of other creditors and the debtors should be in good faith. Without measures to ensure the maintenance of the debtor's activities, the debtor, as a person whose consent is necessary, would hesitate to initiate the procedure, since he would not be interested in it. No one is interested in participating in the procedure to satisfy the ill interests of others. Thereby, it would become impossible to implement and the positive consequences for creditors. The applicant points out that the approach to business entities from the position of let the strongest survive is outdated. Such an approach is possible only with strong economy, and when demand is high and liquidation with the result of bankruptcy procedure does not create social crisis and mass unemployment. The applicant agrees that turnout is based on the life of creditors, but at the same time creditors do not necessarily have a lot of debtors, which means that concessions will not be financially burdensome. If all creditors could be as viable as Dr. Skvortsov, and on the basis of which he erroneously claims that the entire terminus is based on them, the applicant draws attention to the fact that it's worth noting that not all creditors are equally viable. Among them, there are those who are close to non-viability regardless of their debtor, respectively. Some of them will soon act as debtor, and they will need the support of the same former debtors, who this time will act as a creditor in relation to them. In addition, the one who acts as a creditor in relation to the debtor may at the same time be himself a debtor in relation to a third party, where he himself will be referred to receive those privileges that Dr. Olegurich in principle doesn't want to provide to debtors. The picture is the following. We can talk about symptoms, therapy, diagnosis, and doctors. Imagine if a classical music concert organizer has 5 full-time opera singers who were paid in advance to perform at the concerts. 1 out of 5 receive the crown, promised to perform at the next concert for free. The analogy of a debtor with financial difficulties. If he is allowed to go home on the day of the concert. If he is not allowed to go home, he may sing at the concert to the end, but in the end he may die. At the same time, the organizer of the concert has 4 healthy singers. The audience will be happy if they sing longer, and they will not notice the absence of one of them. The remaining 4 singers are healthy and ready to sing longer and help the colleague. For all 5 singers and the organizers, it's better to let the 6th singer go home. That is, to give the debtor respite due to financial difficulties. But it seems that Dr. Larisa insists to force both the sick and the healthy to sing with the same force until the end of the concert, even the concert ends negatively for everyone. As Dr. Skvortsov writes, any creditor has the right to strive to ensure his rights, including in relation to insolvent debtors. The issue of preventive restructuring should be approached not as rough logging, but as more delicate woodwork. Dr. Skvortsov reproaches the applicant for incorrect interpretation of Article 31, from which it follows they provide instant and full repayment of all debts of the debtor or creditors. He calls this a false assumption of the dissertation candidate. You need to speak to the point more. You have violated the time limit. Focus on the most important parts, please, of your answers, please. Let's talk about the grading of conscientiousness. If we talk about the conscientiousness gradation, it's necessary because it depends on the regulation. If we expect from the debtors that agree to a certain pre-bankruptcy agreement, they need to take into account the interests of other debtors. It is a different good faith. They are thinking of others, but they receive something from them. As for the terms, in one part of the review, Dr. Skvortsov says that there is no novelty and everything is extremely bad, but then says that such ideas of selling legal entity, prevention of bankruptcy, this cannot find the basis in the spirit of law nor in law enforcement. If there is no novelty and it has no grounds in anything, then there is a lack of logic about the gradation of consciousness. I suppose I can finish here. Yes, I'll draw the line here. We move on. Dear colleagues and members of the Dissertation Council, is everyone satisfied with the answers? I suppose that we have exchanged opinions. We've listened to each other. Well, unfortunately, the applicant did not understand my comments. As for the institution and your preventive agreement, 15 years ago there was a book, World Agreement. It is not novel. In different interpretation, all that you are talking about already exists. In Germany and in other countries, of course, World Agreement is much better. there is a saying, bad peace is better than a good war. You haven't heard my idea that it all exists. Thus we can I think that Larisa is not denying the fact. She talks about the conditions when the interests of the debtor and creditors be considered. There might be some pirate-like interest, give money, and that's it. But nevertheless, if the debtor has to give the debt, I would like to respond about the world agreement. Very briefly, please. You say that the world agreement can be found in the French law. There are two pre-bankruptcy agreements, but they're different from the author's institution, since the third party is allowed to participate, since it has this cram down. For example, in the Savardo procedure, there is the time limit within which the debtor has to draft the agreement from the moment of the financial difficulty, does not have any more. I can't say that I created a new universum. There are many schemes of arrangements. For example, in UK, the court might agree or not agree if the creditors agree. I was inspired by some elements, but together, all these elements create institution. Maybe it's not very important. I believe that we have received all the answers and we do not have any more questions. Move on to the open.
Диссертация, но не входящих в состав диссертационного совета. Есть ли желающие выступить? Желающих нет. Далее. Оглашение вопросов, поступивших в течение заседаний, касающихся текста диссертации, размещенных на сайте, а также по итогам просмотра трансляции заседания диссертационного совета в порядке обратной связи. На данный момент у нас есть какие-то вопросы? Значит,
Since we do not have any reviews that were received during the, since we do not have any questions received during the broadcast, now we would like to discuss the idea of the supervisor. Vladimir Fedorovich, as a supervisor, I could just state my review. I believe that the dissertation complies to the requirements of St. Petersburg State University. I was listening to the defense attentively, and I would like to say a few words in support of my applicant. I can't provide information to all the remarks, and many were answered and were answered correctly. Maybe the fact that Russian is not mother tongue does not serve as a detriment. As for this agreement, Is it the peace agreement or is it not? Well, tell me please, if we talk about the procedure of financial revitalization, can it be a part of peace agreement? In a way, but this procedure is highly institutionalized. Thus we say that this is a separate institution. The same out-of-court preventive rehabilitation agreement. We are talking about an introducing institution which will be regulated according to the law, and if it can be seen as peace agreement, certain typological differences differed from this agreement. It wouldn't be deep enough. It is very superficial viewpoint. Larisa had a more in-depth approach. As for undeniability, we know that prior to the existing law on bankruptcy, peace agreement could have been considered null and void. But according to the new bankruptcy legislation, peace agreement established by the court cannot be appealed. Only the definition can be appealed. Thus, the protection of rights is fully carried out. The fact what she started calling as impossible to break was what meant. It means that it cannot be appealed. As for pro-creditor, pro-debtor character, friends or colleagues, I'm sorry. When we talk about the bankruptcy, we can talk about pro-creditor, pro-debtor agreement. If we talk about pre-bankruptcy, we are talking about an agreement where all are taking part. This agreement gives many more opportunities to creditors to protect their rights and puts certain balance, and it is absolutely wrong to have such a limited view. As for ill faith and good faith, any principle, all principles of law can be seen through different institutions specifically. In this case, conscientiousness can be seen in a different option as the principle of the freedom of agreement. The fourth and the last aspect, it was voiced that the creditor should demand payment. No, creditor should not demand. He does not necessarily have to demand. It's the right, but the creditor might reject this right. So certain comments were superfluous. The final thing I'd like to mention. The applicant studied in our university at master's program and postgraduate program, and has shown that she is prone to research. And I would like to thank all the members of the Decision Council, and I'd like to thank you for all your reviews and all the comments which I do not consider quite applicable. They provide ground for thought, and I think that Larisa will have food for thought in future. Thank you. Thank you, Vladimir Fedorovich. Does anybody want to voice an opinion? Are there any more questions that we received via email? No more questions. Then this will be the end of the discussion. Prior to the final voting, I would like to ask the members of the Dissertation Council, does the applicant or the members of the Dissertation Council have any comments, objections to the procedure? Each has to say yes or no. No objection, no objections, no objections. Thank you. Then we'll move on to the next point of the procedure. It is 9 o'clock now. 9:01. I think we need to declare a 5-minute break with a muted sound. So let's mute the sound. Larisa and colleagues, you need to leave. We are to discuss the results of the vote, and then we'll conduct the open roll call.
Честно говоря, это сделал формально, чтобы соблюсти формально, потому что как бы мы можем этот этап исключить, но учитывая, что у нас вот так все бурно, да, ну все, мнениями. Ну все, как бы у каждого своя точка зрения. Сейчас тогда мы всех запустим, и каждый огласит, я у каждого спрошу, каждый огласит свой вердикт. Кроме Каменкова, мы его голос не учитываем, потому что он как бы не голосует, поэтому 4 человека участвуют в голосовании, поэтому мы вчетвером будем голосовать, и большинство должно быть высказаться за, если мы говорим о присуждении. Ну, если 2 за, 1 воздержался, то нет. Защита, как бы, степень не присваивается. Вот. Можно, пожалуйста, вас попросить пригласить всех? Пожалуйста, можно вас попросить включить трансляцию, ну, звук. Так. И менее 3. Да. Так, Лариса подошла, все у нас члены здесь. Значит, объявляю перерыв оконченным.
I declare the break over. Thus, dear colleagues, we continue the meeting. Please turn on the sound. This is the decisive moment. Can we see and hear each other? And I raise the question of awarding Mastilovic Larisa to be awarded the candidate, the degree of candidate of legal sciences. I would like to remind you that the decision is considered taken if no less than half of all the members, and but less than 3, took part in the meeting and voiced their idea. Kamenko Sergeyevich doesn't vote. Olga Alexandrovna. I would like to vote for awarding the degree of candidate scientific science of legal sciences. Like Yurievich, your idea. I'm against. Konstantin Borisovich. I'm for awarding the degree of candidate of legal sciences, and I, as a chairperson, vote for awarding the degree of candidate of legal sciences. Thus, dear colleagues and guests, out of 4 people taking part, members of the Decision Council taking part, 3 voted for, against 1, abstained 0. Thus, the decision on awarding Larisa Mastilovic the scientific degree of candidate of legal sciences made at 12:03 civil law, entrepreneurial law, family law, international private law adopted. We give the floor to the applicant. You have 5 seconds. Well, we need to stay till the morning, I suppose. I think I'll make it in 2 minutes. I would like to thank the Department of the Entrepreneurial Law and all the members of the Dissertation Council, Dmitry Alexandrovich Petrov, Professor Karayev, Professor Kamenkov, and Oleg Skvortsov for his sincerity. The questions and the discussion was extremely interesting. I would like to thank Professor Mataus, who is a world-famous expert and who was an external expert who is watching us from Brussels, for his openness, for his benevolence and interest in the legal system of the Russian Federation. I would like to express my gratitude for his inspiring question about the reasoning and the conclusion from my thesis during the preparation of the review. A special thanks to Vladimir Fedorovich Propantopoulou, who's been my mentor for 6 years, starting from the time of studying in master's program and ending with the completion of graduate school. In view of his professionalism, he examines the scientific potential of a student at the very initial stage, which testifies the uniqueness of his pedagogical talents. In scientific societies, such professionals have devoted their lives into scientific and pedagogical activities and do not leave for more pragmatic areas of jurisprudence are especially valuable. This professionalism is eternal in winning 2020 Professor of the Year prize in the field of legal sciences. Thanks for the University of St. Petersburg State University for providing the opportunity to meet respected reviewers and my mentor. I also want to express my gratitude. You might be surprised, but still, I'd like to thank the President of the Russian Federation, Vladimir Vladimirovich Putin, for giving a positive answer to my academic request. Thanks to the decision today, I'm within the walls of St. Petersburg State University. I express my gratitude to the Russian education policies for support of international scientific exchanges. One more sentence, just one sentence left. I need to thank my family, and I would like to express special gratitude to my family, which continuously provide emotional, intellectual, and financial support, for which I can only engage in scientific activities in a free mode. Thank you. Dear colleagues, dear members of the Dissertation Council, we declare the meeting closed. Please turn off the live broadcast.